Hi, I'm Jeff Sifers, the Traffic Safety Resource Prosecutor for the state of Oklahoma. This segment is going to be on the defense of the drug recognition expert in DUI drugs cases. There are going to be multiple and varied defenses that are going to be available to the defense attorney in those cases. Many of them are going to be related to the protocol that a drug recognition expert has to follow. Those DUI defense experts and DUI defense attorneys that do this regularly will already have the drug recognition expert manual. They'll already have the standardized field sobriety testing manual. Those manuals are available online. They are easily accessible. There are multiple trainings available for the DUI defense attorney. Those trainings are going to be specific to the drug recognition expert protocol, and they believe that the defense should always be able to find potential mistakes made by the drug recognition expert while conducting their investigation. The manuals that they have warn that any deviation from the protocol will affect the final conclusion of the drug recognition expert. If the drug recognition expert does not administer the evaluation under the conditions recommended by the manual, the defense will argue that the results of their investigation are not reliable. This is a distraction. This is a challenge by the defense attorneys to claim that a failure to follow a standardized protocol invalidates the opinion of the drug recognition expert. The drug recognition expert takes all factors available from the evaluation into the determination of what categories of drugs were impairing the individual, and then specifically what drug actually caused the defendant to drive under the influence of drugs. Remember that that totality of the circumstances approach is invaluable to you as a prosecutor going forward in laying out your evidence to the fact finder, whether it be judge or jury. Do not be distracted by the protocol and the lack of satisfying protocol that the defense is going to claim. Remember that the totality of the circumstances is your best friend and your best argument before a fact finder. The defense attorney will also claim that the drug recognition expert involves himself in a guessing game. Essentially that he'll do certain measurements and then he'll plug him into a matrix, and whatever the matrix says is what actually was causing the impairment of the individual. While this is not untrue, it's not a guess. These are very simple tools, very simple trades, and very simple things that a drug recognition expert does in determining impairment in the individual. The defense attorney is going to try to undermine the drug recognition expert's knowledge base so that he can later minimize the officer's knowledge before the jury. When a drug recognition expert goes to training, he spends 40 hours in a classroom learning about the drug recognition expert protocol. He learns what he's supposed to do, what measurements he's supposed to take, and the drug matrix and the various categories of drugs and how they affect the human body. He learns these things based upon the training and education of others and upon the studies that were done to give the drug recognition knowledge base. There have been multiple studies done across in the past regarding the drug recognition expert protocol, and the defense attorney will expect the drug recognition expert to know all of these studies, because if he doesn't, the defense attorney will claim that he had no knowledge base from which to draw to determine impairment in the individual. The drug recognition expert shuts this down if he has read all of the studies and is familiar with the studies in drug recognition instruction. He shuts this down if he follows the standardized protocol. He shuts this down if he maintains a good curriculum vitae and is qualified as an expert. He shuts this down if he speaks knowingly about the drug recognition expert protocol. This is nothing more than an opportunity for the defense attorney to try to compare knowledge with the drug recognition expert, and it's important to remember that the drug recognition expert is the only expert in the courtroom, and that the defense attorney who has had a weekend's worth of training and who may have read a manual does not have the opportunity and the knowledge to determine impairment in the individual, and definitely not in the defendant in this case. So to summarize, some best practices for you as prosecutors. Encourage your drug recognition expert to keep their curriculum vitae current. Anytime that they've been qualified as an expert, anytime that they've published any kind of article, any article, scientific article that they've read, that they added to their knowledge base, add to their curriculum vitae, keep it current and keep it available so that you can provide it to the defense attorney or any other judge or fact finder whenever the drug recognition expert has to be qualified as an expert. Remember that the arrest decision is based upon the totality of all things that the drug recognition expert had available. Not just one thing, not the temperature, not horizontal gaze nystagmus, not the blood pressure of the individual. It's the entirety of the protocol and the entirety of the investigation that's available to him. Don't allow things to exist on an island. Don't allow things to exist as a singular concept. It's always the totality that was available to the officer and not what the defense lawyer wants to focus on. Prosecutors, talk to your law enforcement pretrial. Educate each other as necessary. You are not alone going into the courtroom trying to determine whether or not the driver in your DUI drugs case was impaired. The team approach is the best approach. It is a more cohesive, more understandable, and a more powerful tool in front of a fact finder if you all march to the same beat of the same drummer. Remember that any testimony in a DUI drugs case, the officer was the sober person at the scene. He was the DUI professional at the scene, and he is the sole expert in the courtroom in detecting DUIs.